And now for Idaho Real Estate News.
The home buying and selling process at times can be confusing. Questions may arise as to what earnest money is, what it is used for, can the buyer lose it to the seller, or under what circumstances does it go to the seller? These questions and more can be addressed with two simple words. It depends. This is Mike Johnston, contributing editor for Idaho Real Estate News. First, let's talk about what is earnest money. According to an article called Earnest Money on Investopedia.com, they say, and I note that I've made a few minor modifications to the article, making the words used to be consistent with those used here in the state of Idaho. Earnest money is a deposit made to a seller showing the buyer's good faith in a transaction. In real estate transactions, earnest money allows the buyer additional time when seeking financing. Earnest money is typically held jointly by the seller and buyer in a trust account. When a buyer decides to purchase a home from a seller, both parties enter into a contract stipulating the final sales price of the house and the down payment. The contract does not obligate the buyer to purchase the home because reports from the home appraisal and inspection may later reveal problems with the house. The contract does, however, ensure that the seller takes the house off the market while the house is inspected and appraised. To prove to the seller that the buyer's offer to purchase a property is earnest or in good faith, the buyer makes an earnest money deposit. The earnest money paid is put towards the buyer's down payment and closing costs when the transaction is finalized. The transaction is usually finalized after inspections are done and the buyer secures a mortgage with the bank. If the deal falls through, the buyer may or may not be able to reclaim his or her earnest money, depending on how the contract is phrased. If the contract stipulates that the buyer must have the home appraised and it does not appraise for the offer price, the buyer will probably be refunded his earnest money. If the buyer decides not to go through with the house purchase for contingencies not listed in the contract agreement, he is most likely to lose the earnest money deposited. The earnest money is then retained by the seller to protect the seller from any monetary damages incurred from the broken contract and to keep the resolution of damages out of court. The buyer is likely to get his full earnest money deposit back if a failed contingency, such as poor results from an inspection, ensues. Also, if the seller terminates the deal, the earnest money will be refunded to the buyer. Concerns arise when the buyer and seller have agreed that the buyer has a few days before they are to turn in the earnest money. What happens if the transaction falls apart and the earnest money has yet to be turned in? The buyer, if they are the ones terminating the contract, most likely will feel that they do not need to turn in the earnest money because they know they may not be getting it back, depending on the reason for the termination. Contractually, however, they should still turn it in with the understanding that they may lose it, as it was explained in the article above. Contractually, they made the offer in good faith, and when they made the contract, they understood that they may lose it. Let's say that the buyer conducts an inspection and finds something that makes them decide to terminate the contract. If this termination was done within the agreed upon inspection time frame, then the buyer should get the earnest money back. If the buyer fails to close on the property, not due to a contingency specified in the contract, then the seller should receive the earnest money. There is a form that is commonly used to instruct the earnest money holder how to disperse the earnest money. It has been prepared by the Idaho Association of Realtors and is known as the RE-20, Contract Termination and/or Release of Earnest Money. The same form can be used to state that the parties have agreed to terminate the transaction. The termination portion of the form states, the undersigned buyer and seller agree that the above referenced agreement will not be completed and hereby mutually release each other from only the obligation to buy, sell, or exchange the property under the agreement. The release of earnest money portion states, buyer and seller agree that the earnest money pertaining to the above related transaction shall be released and distributed as indicated below, and earnest money holder is hereby instructed to release and disperse the earnest money in the manner stated herein. In the RE21, Real Estate Purchase and Sale Agreement, paragraph 30, the parties agree to the following. If the buyer defaults. Default. If buyer defaults in the performance of this agreement, seller has the option of 1, accepting the earnest money as liquidated damages, or 2, pursuing any other lawful right and or remedy to which the seller may be entitled. If seller elects to proceed under 1, seller shall make demand upon the holder of the earnest money, upon which demand said holder shall pay from the earnest money the costs incurred by seller's broker on behalf of the seller, and buyer related to the transaction, including, without limitation, the costs of title insurance, escrow fees, appraisal, credit report fees, inspection fees, and attorney fees. And said holder shall pay any balance of the earnest money, 1/2 to the seller and 1/2 to the seller's broker, provided that the amount to be paid to the seller's broker shall not exceed the broker's agreed to commission. Seller and buyer specifically acknowledge and agree that if the seller elects to accept the earnest money as liquidated damages, such shall be the seller's sole and exclusive remedy, and such shall not be considered a penalty or forfeiture. Now, if the seller defaults, the comments say, if seller defaults having approved the said sale and fails to consummate the same as herein agreed, buyer's earnest money deposit shall be returned to him, her, and seller shall pay for the cost of title insurance, escrow fees, appraisals, credit report fees, inspection fees, brokerage fees, and attorney's fees, if any. This shall not be considered as a waiver of buyer of any other lawful right to remedy or remedy to which the buyer may be entitled. Some buyers or sellers do not sign the form immediately because they have no urgency to provide the other party with the disputed earnest money. There is confusion as to whom is ultimately responsible to assist the parties when there is a dispute over the earnest money. Part of this has to do with the definition of entrusted funds. The Idaho Real Estate Commission has a guideline that addresses real estate trust accounts. Guideline number 15 on page 79 of the 2020 edition of the Idaho Real Estate License Law and Rules states, broker's duty to deposit entrusted funds into a real estate trust account. A broker is required to deposit any and all entrusted funds it receives into a real estate trust account maintained by the broker, and the broker is responsible for those funds. Any and all funds received by the broker are considered entrusted unless, 1, the parties have directed the broker in writing to transfer those funds to control of a third party, such as a title, escrow, or trust company, and 2, neither the broker nor his licensees have any right to exercise control over the safekeeping or disposition of the funds. Broker's duty regarding funds that are not entrusted. Whenever a broker receives funds with the party's written direction to transfer them to a third party, the broker's duty is to transfer the funds as directed and maintain a ledger record of the time and date of the transfer. He must also obtain a receipt. Because such funds are not considered entrusted, the broker has no duty to deposit them into a real estate trust account under the broker's control. In Idaho, there is a responsible broker, noted on the purchase and sale agreement for each transaction. He or she has the following responsibilities. Idaho Code 54-2048, responsible broker for the transaction, duties and record keeping. The responsible broker, as referred to in this section, shall be responsible to the Commission for the transaction records, the funds and closing in accordance with the requirements of this chapter. The broker who lists and sells any real property shall be deemed the responsible broker in the transaction. In the case of a cooperative sale, the broker who holds entrusted funds in a real estate trust account while the transaction is pending, or who delivers or transfers the funds to the closing agency or any authorized party other than the cooperating broker in the transaction, shall be deemed the broker responsible for the transaction. The responsible broker shall, number 1, ensure the correctness and delivery of detailed closing statements that accurately reflect all receipts and disbursements for their respective accounts to both the buyer and seller in a transaction. Even if the closing is completed by a real estate escrow, closing agent, title company, or other authorized third party, and regardless of the responsible broker's agent or non-agent relationship to the buyer or seller. Number 2, show proof of delivery of the closing statement to the buyer and seller by their signatures on copies of such closing statements, which shall be retained in the broker's transaction file. When signatures of the parties cannot be obtained, a copy of the closing statement transmittal letter sent by certified mail, return receipt requested, or a written certification of delivery signed by an officer of the escrow closing agency shall be retained in the broker's transaction files. Number 3, create and maintain, for the retention periods required in Section 54-2049 Idaho Code, a transaction file containing the following documents as applicable. For all pending, closed, or fallen transactions, the original or a true and correct copy of A, signed closing statements if applicable, B, written and signed brokerage representation agreements, if any. A responsible broker who is representing both the seller and the buyer in a transaction shall retain properly executed brokerage representation agreements in the transaction file and, if appropriate to the transaction, a properly executed consent to limited dual representation statement. A responsible broker who has a signed brokerage representation agreement with only one party to the transaction, either buyer or seller, must retain only that one agreement in the transaction file. C, all offers accepted, countered, or rejected, which must each be retained in the manner required in Section 54-2049 Idaho Code. D, the original or a true and correct copy of all rejected offers must be retained in the files of the selling broker for the statutory records retention period in Section 54-2049 Idaho Code. When there is a dispute for the earnest money, both sides typically dig in and are not willing to try and see the other side. Many times the seller might feel harmed and is not willing to sign a termination agreement because they feel there is no rush to return it and make the other person happy. Sometimes they feel harmed and are waiting until the property gets a new offer, and thus minimizing the loss they feel they have incurred. Buyers may get to the day before closing, and then something happens and the financing that once was approved and good is now unavailable. The seller might feel misled or lied to and demand some sort of compensation for having the property off the market or having lost a potential sale to another buyer. The buyer and seller both need to come to an agreement as to how to resolve this issue. The real estate agents are not the ones that sign the termination agreement or set the time frame for when they are to be signed. I have seen people sign a termination agreement and release the earnest money immediately, while I have seen some disputes that are unresolved and the earnest money is still sitting in a trust account years later. Here is what Idaho law says about disputed earnest money. Idaho Code 54-2047, disputed earnest money. 1. At any time more than one party to a transaction makes demands on funds or other consideration for which the broker is responsible, such as, but not limited to, earnest money deposits, the broker shall A, notify each party in writing of the demand of the other party, and B, keep all parties to the transaction informed of any actions by the broker regarding the disputed funds or other consideration, including retention of the funds by the broker until the dispute is properly resolved. Number 2, the broker may reasonably rely on the terms of the purchase and sale agreement or other written documents signed by both parties to determine how to disperse the disputed money, and may, at the broker's own discretion, make such disbursement. Discretionary disbursement by the broker based on a reasonable review of the known facts is not a violation of license law, but it may subject the broker to civil liability. 3, if the broker does not believe it is reasonably possible to disperse the disputed funds, the broker may hold the funds until ordered by a court of proper jurisdiction to make a disbursement. The broker shall give all parties written notice of any decision to hold the funds pending a court order for disbursement. I noted above in red that the responsible broker may release the earnest money, the entrusted funds, if they are the ones holding them. But then they are the ones who may be sued because they released it without all parties to the transaction agreeing to do so. It can get even stickier. More and more transactions are having the earnest money, the entrusted funds, be held by the closing agency. This is done to facilitate a quicker closing and assist the closer when they are verifying the earnest money that is being held. The Idaho Real Estate Commission states the following, page 78 of the July 2020 edition of the Idaho Real Estate License Law and Rules. Many brokerages are allowing the buyer and seller to place earnest money at title companies and foregoing the keeping of a real estate trust account. In these cases, the monies are not considered entrusted, and the broker has no responsibility to act upon the dispute. This becomes the responsibility of the title company, who has its own laws to follow. In the event a title company is used, the broker is to inform all parties in writing that the title company will handle the dispute according to their procedures and retain proper receipting and ledger card records. So the next question is, who is holding the earnest money? So you know who will be responsible to take care of the situation if there is a dispute over the entrusted funds. If it is a title company, they typically seek instructions from the buyer and seller as to how the earnest money is to be released. All of the title companies that I have spoken with in southeastern Idaho have agreed to use the Idaho Realtors form we discussed earlier, called the RE-20, Contract Termination and/or Release of Earnest Money. As a reminder, this form has two different parts. The top part is for contract termination, and the bottom is the release of earnest money and instructions to holder. Here is where the title company has the authorization to release the held earnest money and it instructs them to whom they are to release it to. With those written instructions, it relieves them from any potential liability that might arise from releasing the earnest money based on what the responsible broker, the agent, the seller, or the buyer may have said. This form is considered written instructions from the parties, the buyer and seller, as to how it will be dispersed. If the responsible broker instructs the title company to release the earnest money, then they require the broker to accept all liability and to hold them harmless and to take care of any problems arising from the instructions to release it. Not very many brokers are willing to assume that amount of liability, and the law does not require them to do so. So again, one might ask, who gets the earnest money and when? I say again, it depends. This has been another segment of Idaho Real Estate News. If you found this article useful, please share it with others. Subscribe by adding us to your Alexa Flash briefing or by sending us an email to Johnston, Johnston, @mykro.com. You can also subscribe to our YouTube channel for more insights on forms and other real estate topics. For Idaho Real Estate News, I'm Mike Johnston.
Idaho Real Estate News is updated weekly.